Hello, everyone, and welcome to Internet Law Review. For today's case, we have JAM versus International Finance Corp., a decision from the United States Supreme Court that deals with immunity from lawsuits or criminal laws for certain international corporations, non-governmental agencies. In this decision by the United States Supreme Court, the court is asked to interpret a law which gave these agencies immunity under the same terms as foreign governments. But the relevant provision here, and the question is that immunity the same as it was at the time the law was adopted, or has that immunity changed in the same way that foreign immunity has changed? In other words, when it talks about foreign immunity, was that frozen or is that floating? So the United States Supreme Court is going to look at this decision and try to figure out that, and we're going to read along with us. Let's see what they decided. In 1945, Congress passed the International Organizations Immunities Act, which, among other things, grants international organizations the same immunity from suit as enjoyed by foreign governments. At that time, foreign governments were entitled to virtually absolute immunity as a matter of international grace and comity. In 1952, the State Department adopted a more restrictive theory of foreign sovereign immunity, which Congress subsequently codified in the Foreign Services Immunities Act. The Foreign Services Immunity Act gives foreign sovereign governments presumptive immunity from suit, subject to several statutory exceptions, including, as relevant here, an exception for actions based on commercial activity with a sufficient nexus to the United States. Respondent International Finance Corporation, an international organization, entered into a loan agreement with Coastal Guarta Power Limited, a company based in India, to finance the construction of a coal-fired plant in India. Petitioners sued the IFC, claiming that pollution from the plant harmed the surrounding air, land, and water. The district court, however, held the IFC was immune from suit because it enjoyed the virtual absolute immunity that a foreign government enjoyed when the exclusion was enacted. The DC government affirmed in light of its decision. So this is a pretty much run-of-the-mill kind of business dispute. Company A lends money to Company B. There's an issue dealing with some finances, dealing with environmental regulations, and so they want to sue each other to reconcile it. Problem is that the Company A in this case is one of these international non-for-profit organizations. So the question is, how much immunity from lawsuit do they get? Can they be dragged into something? Let's see what the court decided. Held. The Immunity Act affords international organizations the same immunity from suit that foreign governments enjoy today under the Foreign Services Immunity Act. The same as formulation is best understood as making international organizations' immunity and foreign service immunity continuously equivalent. The statute is therefore like other statutes that use similar or identical language to place two groups on equal footing. See, for example, the Federal Civil Rights Act and the Federal Tort Claims Act. Whatever the ultimate purpose of the International Organizations Immunity Act may be, the immediate purpose of the Act's immunity provision is expressed in language that Congress typically uses to make one thing continuously relevant and equivalent to the other. That reading is confirmed by a reference canon of statutory interpretation. So when the Supreme Court is referring to reference canon here, there's basically a bunch of default rules that apply on how statutory text is read when you don't have anything else to do. So one of these provisions is that you read things in the context of other things. When Congress is making a list and says, and then other stuff, it's read in the context of the things that are like it, and so forth and so on. General statutory construction rules. And so this is the reference canon the Supreme Court's referring to, these general rules of reading a statutory text. And so they're saying here that if you read this according to these generalized default rules that apply all the other places, you come out with this interpretation, and fair enough. The Supreme Court continues. When a statute refers to a general subject, the statute adopts the law on that subject as it exists whenever a question under the statute arises. In contrast, when a statute refers to another statute by specific title, the reference statute is adopted as it existed when the referring statute was enacted without any subsequent amendments. Federal courts have often relied on the reference canon to harmonize a statute with an external body of law the statute refers to generally. This law's reference to international immunity enjoyed by foreign governments is to an external body, a potentially evolving law, not to a specific provision of another statute. Nor is it a specific reference to a common law concept with a fixed meaning. The phrase immunity enjoyed by foreign governments is not a term of art with substantive content, but rather a concept that can be given scope and content only by reference to the rules governing Foreign Service immunity. The D.C. Circuit relied upon Atkinson's conclusion that the reference canon probative force was outweighed by a provision authorizing the president to alter the immunity of an international organization. So there's a provision in law that basically says that the president can basically waive or alter this with respect to a particular international organization by just so declaring. The idea there being that if an international organization goes off the rails, the president, as part of his powers of head of state, can say, okay, we're going to de-recognize this organization in the same way that president as head of state can just de-recognize an entire foreign government. So it falls within the scope of that kind of action, so it makes sense. Carrying on, the Supreme Court says, but the fact that the president has power to modify otherwise applicable immunity rules is perfectly compatible with the notion that those rules might themselves change over time in light of developments in the law governing foreign services immunity. The Atkinson Court also did not consider the opinion of the State Department, whose view in this area ordinarily received special attention, and which took the position that immunity rules of the statutes were linked following the statute's enactment. The IFC contends that interpreting the immunity provision to grant only restrictive immunity would defeat the purpose of granting immunity in the first place by subjecting international organizations to suit under the commercial activities exception of the law for most or all of their core activities. This would be particularly true with respect to international development banks, which use the tool of commerce to achieve their objectives. Those concerns are inflated. The Immunity Act provides only default rules. International organizations' charter can also specify a different level of immunity, and many do. Nor is it clear that lending activity of all development banks qualifies as commercial activity within the meaning of the statute. But even if it does qualify as commercial, that does not mean the organization is automatically subject to suit, since other waiver requirements must also be met by the statute. Reversed and remanded, written by Chief Justice Roberts. Breyer dissents, and Kavanaugh took no place in this argument because he was not a member of the court at the time, so this is a 7-1 Supreme Court decision. Well, my friends, that is the case of Jam versus International Finance. In this case, the Supreme Court says that international organizations that have immunity only have immunity under the same terms as foreign governments do. And Congress, by its law, has said that there are exceptions to that, including some financial activities. And so this being a financial activity apparently falls within the scope, and so the International Finance Corporation cannot claim this immunity. They're going to have to go to court, and they're going to have to fight it out. Now, of course, they may ultimately win in the lawsuit. This case has nothing to do with the underlying lawsuit at all. It doesn't touch on it at all. So I'm in no position to offer an opinion as to which of these parties would win. The only question is, can there be a lawsuit at all? And the Supreme Court says, yes, there can be. So they'll still have the right to go to court, they'll still have the right to argue, and they may very well win, for all I know. But they do not get an immunity because foreign governments, which, if anything, would be entitled to more immunity, one would imagine, would not get immunity under the same circumstances, so therefore, they can't get immunity either. Seems perfectly reasonable. But for now, my friends, that is all. I hope you're well. Till later. Cheers and goodbye.